have had to consider moving back home or just moving because of many push factors such as the breakdown of marriage, the loss of immigration status, unemployment, and perhaps other pull factors such as family and friends back at home. With the decision for a parent to obtain leave to relocate from jurisdiction is a costly and risky process. And some parents make that decision to leave jurisdiction without leave of court or consent from the other parent. Where a child is unlawfully abducted or retained and an order is made for the swift return of the child, psychological material available appear to suggest that the return of the child may even be re-traumatizing. So, should a parent's past conduct in their unlawful retention or abduction entail that a relocation application be that much more difficult? Today, this morning, we have a panelist, and through the wonders of the internet, a panelist from all around the world. Kiran Daliwal, a partner from YN Fu & Partners, Malaysia. Jeremy Morley, from the law office of Jeremy D. Morley, the United States of America. And from Australia, Keturah Sageman, senior partner from Nichols Family Lawyers, Australia. And this panel will be moderated by Mr. Yap Tiong Liang, our director, TL Yap Law Chambers, LLC. Just as a quick reminder to everyone, questions regarding this session can be submitted through the MicePad platform Q&A function. Over to you, Tiong Liang, and to the fellow panelists.
Thank you, Darren, and good morning to everyone and our distinguished guests. Welcome to Singapore, or should I say welcome to the Singapore time zone. Session 2 is titled Relocation versus Abduction. Fight or flight. Is abduction a hindrance to return? I'm privileged to moderate this session with a panel of experts from Malaysia, Australia, and New York who will share their perspectives on how the courts in their respective jurisdictions approach issues of child abduction and relocation, and whether a return order under the Hague Convention is a hindrance to a subsequent application for relocation. I will multitask and share the Singapore's perspective in these areas. We will also discuss how, if at all, in light of the current COVID-19 pandemic, this situation may have influenced the court's decision in relocation applications. All of you would have received the slides setting out a hypothetical case study, which will be the backdrop of our discussions this morning, and which we will embark upon when we discuss the various issues. I will take it that the case study has been read, but I will just briefly touch upon some of the facts. Here we have Sergio, the husband, who is a UK and US citizen working as an investor in New York. Marion, his wife, is an Australian citizen working in New York as a CFO of a company based in Sydney. Sergio and Marion commenced their relationship in 2011, and Marion moved into Sergio's apartment in New York. They married in February of 2012 and had a beautiful child, Sophia, in 2012, born in New York. Sophia holds dual citizenships of US and Australian and is now 9 years old. In 2014, Sergio began traveling overseas more frequently and would spend about 6 to 9 months in a year in London, returning home to New York for a few days at a time. Sophia commenced her school education in 2017 in New York. The frequent travel between London and New York took a toll on Marion and Sophia, who felt that she was raising Sophia alone. They had arguments in Sophia's presence. Marion has alleged that whilst in London in about 2018, they had an argument and domestic violence occurred in which Marion suffered injuries, and the domestic violence was witnessed by Sophia, who was traumatized. The couple entered into an agreement with their own legal advisors, respectively, to work on their relationship. They were to live as a family in Sydney, where Marian would have her family support. If the relationship did not work out, part of the agreement was that they will all return to New York. The family went to Sydney, Australia in mid-2020. Sergio maintained his New York apartment. Sophia maintained her place by way of reservation in a school in New York, although she was enrolled at school in Sydney for her education. Marian claims that unfortunately a second incident of domestic violence occurred whilst they were living in Sydney. This time, Sergio had allegedly committed family violence on Sophia, and Marian this time asked Sergio to move out. Sergio returned to New York about 6 months later, in December of 2020, and consulted lawyers who informed Marian that the relationship had failed and that she must return to New York with Sophia in accordance with the agreement they had. Marian refused to return with Sophia to New York as she felt unsafe subjecting herself and Sophia to domestic violence with no family support in New York. Sergio instructed the Central Authority to commence proceedings in Sydney under the Hague Convention on Child Abduction for the return of Sophia to New York. The Family Court of Australia in March of 2021 found that Sophia's habitual residence was in New York and ordered her return. Sergio provided the undertakings to the court relating to domestic violence and not to commence criminal proceedings against Marian for the wrongful retention of Sophia in Sydney. Marian complied with the return order. Once back in New York, proceedings commenced where both Sergio and Marian sought child arrangement orders. Marian sought relocation of Sophia back to Sydney on the basis that it was in Sophia's best interest to be relocated, where she had family support. Marian's employers now require her to be based in Sydney. Moving forward now, given this case study and this factual background, I'd like to ask Keturah to kick off the session and ask her to share the Australian perspective in relation to habitual residence in the Family Court of Australia granting the return order, the grave risk defense under Article 13 of the Convention, as well as the undertakings that the courts will or may require in such a situation. Keturah, over to you.
Well, thank you for that, TL. Okay, so firstly, Australia and the US are contracting states to the 1980 Hague Convention on Child Abduction, and that provides a framework for the prompt return of children to their place of habitual residence when they've been wrongfully removed. Sergio will have contacted the US Central Authority alleging wrongful retention of Sophia in Australia. They would have contacted the Australian Central Authority, and an application would have been made to the Family Court under the regulations which gives effect to the Hague Convention. Firstly, the Australian Family Court needs to look at the jurisdictional facts for the Central Authority to establish wrongful retention. Firstly, was the subject child under 16 years of age? Yes, Sophia is 9 years old in this scenario. Was Sophia habitually resident in the USA immediately before the wrongful removal or retention? In this case, the court found that proved. Does the requesting father have rights of custody? Well, yes. In this case, he has guardianship and he has the right to determine the place of residence of Sophia. Was the retention of the child in breach of the father's custody rights, which he was exercising at the relevant time? Well, the answer is yes in this case. And on the fact scenario, the court did find that the child is habitually resident in the USA. So looking at habitual residence, the question for the Australian court is, where was the child habitually resident immediately before the date of the alleged wrongful retention? Australian law on habitual residence is settled by a 2009 High Court case known as LK and the Director General, Department of Community Services. Habitual residence is a question of fact and requires evaluation of all relevant circumstances. It's a broad factual inquiry and will look at whether there was a settled purpose and the actual intended length of stay, in this case Australia. The settled purpose does not have to be for a permanent stay. Here the family went to Australia in mid-2020. There was an agreement between the parties to return Sophia to the US if the parents' relationship didn't work out. The mother failed to return Sophia when this occurred. The father's agreement was only for a temporary stay in Australia. However, the parties appeared to have different intentions. The Australian courts have recognised that just because the purpose of an international relocation of the parties is to work on their relationship, it doesn't necessarily mean the purpose in relocating cannot be regarded as settled. Relevant circumstances include what are the strengths of the child's ties, in this case to the US. Sophia was born and raised there. She went to school there from 2017, and she even maintained her place at school in the US. So she was living in the US for what would be considered an appreciable period, and that's a relevant phrase. Sophia is also a dual US and Australian citizen. What then is her degree of assimilation into Australia and her living and school arrangements? Cultural, social and economic integration. Well, on the facts, she was enrolled in school in Australia from mid-2020, presumably, but was she really integrated into life in Australia at the time of the retention? Well, Marianne might say her employment requires her to be in Sydney. However, it may be harder for her to argue that Sophia is actually integrated into Australian life. In Australia, the courts have acknowledged a shift away from the focus of shared parental intention in determining habitual residence. Rather, the focus should be on whether the child's presence in Australia has a degree of settled purpose from the child's perspective. Now, Marianne was the respondent in these proceedings. So for Marianne, ultimately none of the exceptions did apply, and the court found that the child had to be returned. However, she could have argued a defence of grave risk, and one of the exceptions to a mandatory return is if there is a grave risk that if returned, Sophia would be exposed to physical or psychological harm or otherwise placed in an intolerable situation. If this exception is made out, the Australian court has a discretion to refuse to return the child to the US. And Marianne, as respondent, bears the onus of proof to prove grave risk of harm. In this case, Marianne claimed 2 incidents which involved physical or psychological harm. So in 2018, Sergio struck Marianne in the face and she consequently hit her head. This occurred in Sophia's presence and the child became traumatised. The second alleged incident of domestic violence occurred in Sydney, and that involved Sophia being slapped in the face by Sergio with such force that a tooth fell out. Now that sounds quite severe. Marianne must establish that the grave risk is substantial. Sergio is likely to deny the incidents or give a different account of the facts. He may argue that Marianne was never injured and that Sophia's tooth fell out, but it was nothing to do with her being hit by him. It's the task of the trial judge to make findings of credit of each party. Who does the trial judge believe? The mother's evidence or that of the father? Marianne may seek to prove the effect upon her mental health of a return to the USA, where she alleges she had previously suffered from emotional distress and mental health issues would lead to a grave risk of psychological harm to Sophia. She may have to put on evidence of a psychiatrist as to any impacts on her mental health deterioration if she was required to go back to the USA. However, according to the legal principles, disruption, uncertainty and anxiety that will likely recur and may well be magnified by having to return to the country of habitual residence is not in itself sufficient to establish the grave risk of exception. It's a pretty high bar. Further, grave risk from the Australian court's perspective is confined to circumstances arising from the child's return to the country of habitual residence, that is the US, not to the return of the child to the left behind parent, namely Sergio. So according to High Court authority, the court may still in its discretion order return, even if the exception of grave risk is established on the facts. And some matters that bear on the exercise of that discretion include conditions on which the return may occur and whether judicial proceedings will take place in the country of return, so in this case the US, and whether there are suitable interim arrangements for the child if the return is ordered, and care must be taken to ensure that those conditions will be met voluntarily, or if not met voluntarily, that they can be readily enforced. The Australian court is likely to assume that once Sophia is returned, the courts in the US are appropriately equipped to make suitable arrangements for the child's welfare. Therefore, unless there is evidence that the US does not have courts or services which provide protection for Sophia, then it may be difficult for Marianne to establish the grave risk of harm exception. What then about the undertakings that were offered by Sergio? Sergio provided undertakings to the court, presumably not to commit family violence, and to offer Sophia and Marianne a safe place to stay on their return to the US. Sergio also gave an undertaking not to commence criminal proceedings against Marianne for wrongful retention if she returned to the US. Marianne may have argued that there is a grave risk of harm if she returns to the US with Sophia because of the risk of being held criminally liable for removing the child, and if she was incarcerated, that may lead to a separation from her and Sophia. This would have obviously a profound detrimental psychological impact on the child. An undertaking by Sergio not to commence such criminal proceedings could allay Marianne's concerns and satisfy the court that the risk is averted. The Australian court could have imposed conditions, or it may have required such undertakings to enable the soft landing and to note such undertakings in the return order. Any breach of an undertaking to the court may be considered a contempt of court, so it's a fairly serious matter. And so I think I'll leave it there, TL, in terms of how the Australian court deals with those issues. Thank you.
Thank you very much, Keturah. Thank you. Jeremy, turning to you now, I think in the US, right, the question of the grave risk has certain very specific connotations, and we now look forward to you sharing the New York perspective on the current facts that's before us. Thank you, Jeremy.
Thank you. Thank you, TL, and thank you to the Law Society for creating such a wonderful program. And greetings from the Big Apple, where it's now almost midnight. So, the outline that Keturah just so well made of Australian law is not dissimilar to the US approach. I'm going to focus on some of the peculiarities of the US approach. There are many, but I'll focus on some of them. With respect to habitual residence, everything changed last year when the US Supreme Court adopted a new test. It was the first time that habitual residence was before the Supreme Court in a case that is now famous called Manaski. And the good news is that the test has now been clearly and simply stated. The bad news is that the test has been clearly and simply stated. The test is simply that of the totality of the circumstances, whatever the heck that means. It means that anything is relevant, I guess. One thing that is clear is that the old rule that dominated a majority of the U.S. Circuit Courts of Appeal, which was a focus on the last shared intention of the parents, has now basically been abandoned and has been replaced by looking far more at the situation through the eyes of the child. So we're looking for, to answer a question, where did Sophia think was her home on the relevant date? We've got a great case study, but we would need more details for me to be able to give an answer. I'm not going to go through the analysis that Katura made, but I would say that I would need to go through more facts. I'd like to know where Sophia's friends are, whether she has more there or here. It seems that she doesn't have family in New York. I'd like to know how close she really is to the family in Sydney and how established she's been with the family there. I would like to know where the stuff is. By stuff, it seems like everybody in America knows what I mean when I say, where's your stuff? I don't know whether that translates into Singapore. But where are your belongings? And where is Singapore's stuff in particular? Did they ship it or did they keep it in the States? Big question, where's their furniture? So did they, to me that's a big deal. Did they move the furniture over? Or did they go shopping? Or when they went shopping, I just checked before I got online, you do have IKEA in Singapore. If they went to IKEA and they're rich, then they're staying for a short time. But if they went to some fancy designer furniture store, then that was an indication that maybe they were intending to stay or planning to stay for a longer time. And especially if Sophia was part of that program, it would be very helpful. I'd like to know how well she settled into school. I'd like a comparison of her life in the two schools. Also, with respect to the intention question, I would like to know whether there was, I think I would raise the issue, depending on who I was representing, of whether there was an implied term when the deal was that they were going to go back if it didn't work out. Was it implied that Sergio was supposed to be a good boy? Was he supposed to do better and work on the relationship? He's the one that seems to have sabotaged the relationship, and maybe it's wrong to reward him for that sabotage. I would note, in comparison to what we just learned a little earlier from the Honorable Judge, that these issues in the United States are going to be primarily by means of live witness testimony with intense cross-examination and perhaps almost certainly with prior deposition testimony and a lot of discovery. My final point on habitual residence is that the Supreme Court in the Manaski case said that these issues of habitual residence are fact issues for the consideration, for determination by the trial judge, and basically don't bother us on appeal as long as the judge recites the correct test, totality of the circumstances. We're basically not going to interfere. With respect to grave risk, in the United States, what's different about grave risk is that we have a battle of the experts. Our courts, unfortunately, do not always, in fact, rarely appoint a psychological or psychiatric expert. We do it ourselves. We hire hired guns, and it's a battle of the experts. That creates huge expense, huge delays, and often huge unfairness. If a petitioner is poor, as a matter of fact, she gets an advantage, or he or she gets an advantage, because the U.S. State Department will refer the petitioner to a top law firm to act as pro bono counsel, and they will generally hire top experts. If the mother is on either side and is claiming domestic violence, she may well persuade a women's protection organization to come to her rescue. If a middle-class litigant doesn't have those quote-unquote advantages, then that middle-class litigant is in big trouble, because these cases are mega expensive, and that can be mega destructive. Hate cases are ridiculously expensive because of live testimony and so much pretrial work. I want to point out also that the grave risk issue is, like almost everything else today in America, is heavy-duty politics. On the one hand, we have the people who say that when a parent flees overseas with a child because of domestic violence, it would be inhumane to send her back with the child to the place where the bad things happened. The other side of the equation, the other side of the debate is the convention is intended to deter international child abduction, and more than 100 countries now are treaty bound to respect the court processes in each other's countries. With respect to undertakings, it's another area where there's big confusion in the states. When the convention was first signed, we didn't see undertakings. There was a reference by the U.S. State Department recommending when the initial act bringing the convention into American law was enacted, that undertakings were inappropriate in this area. Court decisions in more recent years have changed that. Now it seems actually there's one case where I think the U.S. Supreme Court is about to grant certiorari, meaning accept a case on this issue. That should come about within the next couple of months. Meanwhile, I'll just refer to one case. The issue came to Seattle, Washington 2 weeks ago. An American mother removed a child from her home in France to Seattle, claiming physical violence by the father and claiming that he was a child pornographer and had cut her off financially, and she had been homeless in France. And a very sad tale. The trial court upheld her testimony, believed her, and upheld the grave risk defense. On appeal, the U.S. Court of Appeals for the Ninth Circuit, in a case called Re-ICJ, ruled just a couple of weeks ago that before denying a Hague petition on the grounds of grave risk of harm, the trial court should have considered the availability of alternative remedies that would allow both the return of the child to France and protection from harm. And critically, it said the correct question is not whether the child would face a risk of grave harm if she permanently resided in the country of habitual residence. Instead, the proper question was whether she would face such a risk during the immediate period prior to the courts in the country of habitual residence making a custody determination. This, it held, required the trial court to hear evidence as to what measures might work to provide the necessary protection and how these issues would be treated in the country of habitual residence, in that case in France. And so the court sent the case back to the trial court and basically said, do a better job. In a case recently in Canada, I testified as the expert witness about the laws and procedures about child protection and spousal protection in the U.S. state of Minnesota. And the court accepted the mother's testimony that the father had been violent, but it held that Minnesota has strong laws and strong systems to protect vulnerable children and women, and therefore it ordered the return of the abducted child. So Canada follows a similar path. The grave risk argument in general uses up a vast amount of judicial time in the United States. I'm hopeful that expanding the use of undertakings will now substantially reduce the availability of the grave risk defense. I want to say just a couple of words about the undertakings specifically ordered by the Australian court. Would that work in the American system? Well, the bar against domestic violence, we can probably get a New York order of protection pretty easily, but the no criminal prosecution promise is not enforceable. Obviously, prosecution is the responsibility of the state or the federal government. It's not a private matter. And so Sergio's commitment not to report the matter to the authorities might well be unenforceable as a violation of New York or US public policy. We can talk about how we might get around that, but it would create a difficulty. Lastly, the assumption that automatically New York has child custody jurisdiction may not be correct. That is, we have a very unusual uniform law that is enforced in every American state except Massachusetts, called the Uniform Child Custody Jurisdiction and Enforcement Act. It sets forth different connecting factors. The fundamental connecting factor is that of the home state, which is where has the child lived for the last 6 months. The fact scenario in this case talks about 6 months. I'm not sure which way it can go. I think in the end, a New York court will have jurisdiction, but the family court judge in New York is going to have a tricky time getting there. I think they will get there in the end, and I don't have time now to go into the ins and outs of how exactly that would work. I just want to also point out one thing about this Uniform Child Custody Law. We register foreign court orders as long as there was jurisdiction in the foreign country, as jurisdiction under US principles, under UCCJDA principles, as long as there was what we call due process, meaning basically the litigant had the chance to appear. It may very well be in many Hague cases that it is far better to register a court order from the place from which the child was abducted, register that in the American court, and that will avoid grave risk as a defense or exception, objections of a mature child waiting 1 year and the child becoming settled, and the other exceptions that are set forth in the Hague Convention. I think that I am going to leave it at that, except to make mention, I know that TL wanted us to refer to the COVID issue.
Yeah, we could do that later, Jeremy, probably in the context of the discussions on relocation, in terms of the choice of destination of the relocating country. Thanks, Jeremy. Kiran, over to you now. Now, Malaysia is not a signatory to the Hague Convention on Child Abduction. In this particular case, what options would then be open to Sergio in relation to trying to secure a return of Sophia back to New York? Kiran, over to you. Thank you.
Thank you. Good morning, everyone. Firstly, thank you to the organizers for giving me this opportunity to present Malaysia's perspective as the non-Hague Convention country on the panel. Before I begin, I would first point out that in Malaysia, we have a dual system of family laws. The Sharia for Muslims, and for non-Muslims, applications are made to the civil courts. I will address only the civil aspects that apply to non-Muslims. Now, what if Marianne retains Sophia in Malaysia? What can Sergio do? Even though all parties are not Malaysian, the Malaysian court does have jurisdiction under the Law Reform Marriage and Divorce Act. This is because the Act applies to all persons in Malaysia. The Malaysian Court of Appeal, in the case of Nedun Chalayan, had occasion to consider whether the Law Reform Act applied to foreigners. The Court of Appeal held that the Act applies to all persons physically present in Malaysia and not just to those ordinarily resident. So, Sergio would have jurisdiction to make an application in Malaysia for custody of Sophia. He will also seek leave for Sophia under Section 101 of the Law Reform Act to be taken out of Malaysia, either unconditionally or subject to such conditions or undertakings as the court may think fit. So even where Malaysia is not a signatory to the Hague, there is provision within the Law Reform Act for the court to set conditions and seek undertakings from Sergio or Marianne, or both of them, before making an order for Sophia to be returned to New York. It is specifically provided in the section that failure to comply with an order under this section shall be punishable as a contempt of court. Now, what are the principles that would be applied? The overriding principle in all applications regarding children in Malaysian courts is that it is the welfare of the children that is the court's paramount consideration. In a case like Sergio and Marianne's, where a child is brought to Malaysia, as a starting point, the court will first consider whether the child is a long-term resident here, either as a Malaysian citizen or a child of Malaysian permanent residence, or whether the child is a transient visitor because they are children of foreign nationals. That phrase, transient visitors, was coined in the same Court of Appeal case, Nedun Chalayan. That case had a similar factual matrix to Sergio and Marianne's. A Malaysian mother had come to Malaysia from Canada on holiday with her 2 children and her Canadian husband. The children were also Canadian. A return date was set for the family to return after the holiday. However, shortly before that return date, the mother commenced custody proceedings in which she sought orders to retain the children in Malaysia. She too raised issues of domestic violence. The mother was successful at the High Court, and she had custody of the children and an order to remain in Malaysia. The court also made a finding that the mother was justified to refuse to return to Canada for fear of her life and safety, and granted her custody of the children, who were then 5 and 3 years old. However, on appeal to the Court of Appeal, the High Court order was set aside. The children were ordered to be delivered into the care and custody of the husband, who was at liberty to remove the children to Canada, and the court had recommended that the removal take place as soon as possible. This was to ensure that the children don't settle roots in Malaysia. In making the return order, the Court of Appeal had recognized that the Malaysian court did have jurisdiction and power to make any order required for the protection of children who are physically in Malaysia. However, the court did distinguish and recognize that there was a critical difference in the duration the protection will be accorded to a child who was a long-term resident and one who was only a transient visitor. If a child is a transient visitor, the duration of protection should only be for so long as the child can lawfully remain in the country. The court also should only intervene if the harm to the child could be classified as a real and immediate danger to their physical well-being from anyone, including their parents. The court held that when dealing with cases involving transient visitors, it was not desirable for the Malaysian court to make a full inquiry into the marital disputes. Instead, the court only needed to be satisfied that no obvious harm would come to the children by sending them back to Canada. In addressing the allegations that the mother had raised of domestic violence, the Court of Appeal found that the mother had only made a bare assertion against the father, and there was no credible independent evidence to support her allegations, and further that the children were in no physical danger from the father. The Court of Appeal had made clear that in ordering the care and custody to the father and their return to Canada, the court did not make any concluded view as to which parent should have the permanent custody of the children, as that was a matter to be dealt with by the Canadian courts. Similarly, the fact scenario in Sergio and Marianne's matter would mean that Sophia would be treated as a transient visitor in Malaysia, as she is a child of foreigners, with no right to remain indefinitely in Malaysia. She had been in Malaysia for about 6 months by the time Sergio had returned to New York. The Malaysian court will therefore apply the welfare principle slightly differently and limit itself to weigh what danger would there be for Sophia to return to her country of origin, and for that court, the New York court, to determine the issue of custody. In light of the issues of domestic violence raised by Marianne, if the court had any concerns regarding Sophia's safety, conditions could be set and undertakings requested from Sergio and Marianne as necessary, and this could also include the need for mirror orders to be made in New York before the return order can be implemented. I would actually suggest that Sergio tries to obtain an order from the New York court for Sophia to be returned, which New York order would actually be, while Malaysia would not be bound to follow that order, it will give weight to the order, and it would mean that Malaysia could recognize that New York was already seized with jurisdiction and the custody dispute will be dealt with there. There was another Malaysian case involving Australians where the father had thought to take advantage of the fact that Malaysia was not a member of the Hague Convention. Parties had been estranged for some time, and he had taken his 10-year-old daughter ostensibly for a holiday to Europe. Instead, he made his way to Malaysia, enrolled her in a school, and he applied for a long-stay visa under the Malaysia My Second Home program. The mother had initiated proceedings in Australia, which also resulted in the cancellation of the child's Australian passport. In that case, the Malaysian High Court found that Australia was the forum with the most real and substantial connection, the parties being Australian citizens. The welfare principle was applied, and in the interest of justice, the court found that it could not countenance parental abduction, and the child was to be returned to her home country unless there were compelling reasons to the contrary, or the child would come to harm if she was returned. conclusion, while Malaysia is not a Hague Convention country, the principles that have been applied by the Malaysian courts will have a similar outcome, in that a child will be returned to their home country. There is, however, the disadvantage that the process takes longer and higher legal fees will be incurred, as we do not have the expedited protocols that are available between Hague Convention countries. But listening to Jeremy and Ketura, I'm not sure. It seems like the process there seems quite long as well. There remains the question of how the Malaysian court will deal with a situation where a Malaysian child is brought back to Malaysia. There have been no decided cases on this point. Following the Court of Appeal in the case of Nidin Chalayan, the court will deal differently with a Malaysian child or one whose parents are permanent residents of Malaysia. In fact, the Law Reform Act applies to all persons domiciled in Malaysia, even if they are resident overseas, and a citizen of Malaysia is deemed domiciled in Malaysia until the contrary is proven. So where a Malaysian court is dealing with a child who is a Malaysian, it is likely that a return order will only be made if it can be proved to the court that the child is domiciled elsewhere. The argument can be raised that a child has spent a considerable amount of time in another country, even born there, and the Malaysian court, in its role as the parent's patria to the child, may be persuaded that it would be in the child's interest to be sent back to the country of habitual residence. Now, the issue of return of a Malaysian child has been the stumbling block that Malaysia has faced in ratifying the Hague Convention. However, by not being a party to the Hague, Malaysians also face issues. Firstly, by not being able to seek the automatic return of Malaysian children abducted out of Malaysia. And secondly, Malaysian parents who seek to bring their children to Malaysia for access are usually faced with reluctance from courts in Hague Convention countries for fear that the children may be retained here. Thank you, Tia.
Thank you, Kieran. From hearing all of you all speak, right, on the question of habitual residence, the Singapore courts, obviously, when we deal with applications for return under the International Child Abduction Act of 2010, the focus of the inquiry is the question of habitual residence, not at all to deal with the welfare issues. That will have to be dealt with depending on where the courts make the finding of habitual residence. But again, hearing it's a question of, it's a factual inquiry quite clearly, and I think Jeremy pointed that out, right? There's a lot of information missing, and with that factual inquiry, the case could go either way because there will be arguments, right, for and against. But here in this particular factual scenario, I would just want to highlight that parties do have an agreement for Sophia to come to in this case to Australia, but assuming it was to come to Singapore, the application would probably be an application under Section 8 of the ICAA for the wrongful retention of the child in Singapore, and not so much the wrongful removal. And that inquiry in which the Singapore court, the Court of Appeal, had dealt with was a case in 2017 in the case of TUC and TUD, right, whereby the court did take into account an agreement between the parties for the children to be brought from the US to Singapore. Essentially, that agreement was for the parties to try and work out their marriage in Singapore. And hopefully, if that works out, things will be fine. There was no specific timeline. But eventually, what happened, then the mother, in that case, commenced divorce proceedings. And when that transpired, from the father's perspective, it was basically all bets were off. And he wanted the children to be returned to the US. Mother naturally did not. Arguments were raised that the children were settled in Singapore already by then. And hence, right, there was no return, right, to be made. Eventually, the court decided that the agreement was only go so far as to look at the intention of the parties. Right? The question of settledness is again a separate factual inquiry. In that case, the period of stay in Singapore was not long. I think it was about 4 months or so. Father acted speedily in terms of making the application for the return to the US, and eventually the court, right, did order the return to the US of the children. And as I understand it, now the kids are actually doing well in the US back home. And obviously things have taken its natural course in that sense. So that's the in short brief, right, how the Singapore courts look at it. Certainly I think there is commonalities in the approach. Certainly in the question of the defense under Article 13B of the Convention, in the case of BDU and BDT, again, the Court of Appeal dealt with the question of the undertakings. And just to take on board what Jeremy mentioned earlier, the sabotage, right? And it was held by the Court of Appeal, right, in BDU and BDT, that an abducting parent could not seek to rely on his or her own conduct in order to create a situation of grave risk of physical and or psychological harm to the child concerned, in order thereby to rely on the alleged risk to argue against the return of the child pursuant to Article 13B. This was based on the broader rationale to the effect that a person could not take advantage of his or her own doing in that regard. On our factual case study, although we've cited 2 incidents, I think part of the inquiry would be, right, are these one-offs, or has there been a history, right, during the course of their relationship and their marriage, right, of any domestic violence issues. Moving to the role of undertakings, the Court of Appeal in BDU had come to the conclusion, right, that there was a very detailed list of undertakings, right, that was prescribed before the ordering the return, right, of the children to Germany. And the Court of Appeal held, right, that the role of undertakings was crucial. Not only were the undertakings by the parents seeking the return of the child a sign of good faith on his or her part, they were also important in ensuring that the return of the child would not, as far as possible, adversely impact the child and or the abducting parent. The potential difficulty, obviously, and that's recognized, is ensuring that the undertakings were complied with. But one can imagine, I suppose, if there was a return order, very quickly back to the home state, applications would be taken out to determine welfare issues fairly speedily in that regard. And I suppose the undertakings, if at all, right, are temporary measures to secure the return of the children, and the courts of the home state will have to take it forward thereafter in relation to any further orders it would make in the interest of the children. And on that note, I suppose we can now move to the question of a relocation application, right, on the assumption that now the children are back, right, to the home state. And how would the fact that a return order having been made, right, or the fact that there is in existence an agreement between the parties, how would that impact the courts, right, in relation to any decision they would be making, whether to order the return of Sophia in Sophia's interest? Now, when we discuss this, perhaps we could also dovetail it into how COVID-19 pandemic, given the different policies each country has taken, different seriousness of how the country and its people have been impacted by COVID-19, how have the courts taken that on board, right, in its decision, whether to order a relocation or perhaps to withhold the relocation for the time being, or the stay in order for relocation, pending certain things improving in any particular country, for example. So with that, I was just going to suggest perhaps, Kiran, you could now kick us off, right, on the discussion on relocation. There will be certain facts that I think will change. I think that we probably do not need to be too overly focused on shifting the facts, but really the principles, right, a court will apply when looking at a relocation and how it takes into account, right, the existence of a return order on an agreement or the COVID pandemic impact. Thank you, Kiran.
Unmute.
Yeah.
So we're now back in Malaysia, and Marianne wants to apply to relocate back to Australia. Now, to be successful, Marianne will need to set out a comprehensive account of her intended care arrangements in Australia with as much detail as she can. In Singapore, this has been referred to as the relocation plan. Now, this is a very fact-centric exercise, and she needs to set out her intended residence in Australia with details, the educational arrangements for Sophia, the more specific the better, the day-to-day care arrangements, including while Marianne is at work, the details of the family support Marianne says she has in Australia and why that is important, and what access arrangements will Marianne facilitate for Sergio, and how will that be possible? Now, the question remains whether Marianne's earlier retention of Sophia in Australia will be an impediment. In fact, we had a similar issue in a recent case where we represented the father. It was an application made by a Malaysian mother to relocate with her Malaysian child to the Netherlands. Prior to the mother's relocation application, the family had been living in Holland for about a year and a half, and the mother had tried to remain in Holland when the father was due to return back to Malaysia. Now, in the Netherlands, they had already commenced proceedings. The father had contested those proceedings, and the Dutch District Court had ordered the child to be returned to Malaysia with the father. This order was then affirmed by the Dutch Court of Appeal, and both the Dutch courts had decided that it was in the welfare of this Malaysian child, a 6-year-old girl, to return to Malaysia with her father. Upon their return to Malaysia, as Marianne seeks to do, the mother applied to the Malaysian High Court to relocate. The court granted custody to the father and refused the mother's relocation. Now, the court had taken into account the welfare and interest of the child and had made the following findings. The court found that the mother had not set out specific details of her living and care arrangements for the child in the Netherlands. There was no specific disclosure on the child's continuing education opportunities in the Netherlands. The father, on the other hand, had established a stable care arrangement in Malaysia, and the child was enrolled in school in Malaysia. The judge in that case had concerns that weighed heavily on her as to the fact that a Malaysian relocation order would be contrary to the Dutch return order. The issue had not been appropriately addressed by the mother, and the judge had concerns that if the child was allowed back to the Netherlands, there would be relitigation in the Netherlands as the Dutch return order remained a valid and enforceable order. This uncertainty, the judge felt, would then subject the child to unnecessary risk and uncertainty, as the mother had not mitigated that issue. The judge had found also that the mother, both in the Netherlands as well as in Malaysia, had restricted the father's time with the child, and this too had raised concerns. So in Marianne's case, it is therefore important that she makes it clear in her relocation application how the Australian court will deal with the Malaysian order for Sophia to relocate back to Australia. An opinion from Australia would be necessary to confirm that the Australian courts will not, upon a relocation, again order a return of Sophia back to Malaysia. It is also imperative for success that Marianne sets out her full arrangements and makes clear that her earlier retention was not in any way to alienate Sergio, and in relocating, she will facilitate access. The court will undertake the whole balance of all these factors and make the decision that it feels would be in the welfare of Sophia. The COVID-19 pandemic would just be one of those factors that would be put into the whole basket of things that the court would look at and put into the balance. So yeah, it would be very hard to say whether the child would be returned or not. It is extremely fact-centric. Thank you.
Thanks, Karen. And Jeremy, your take on a relocation, a subsequent relocation application after a return order has been made?
Yeah, again, it definitely depends. In New York, the leading case is a famous case called Tropea, Tropea. It's already 25 years old. But the law is very similar to the law that was just outlined by Kiran in Malaysia. We have a laundry list of factors, and it's a very fact-sensitive case, and the fundamental legal focus is welfare, or what we call best interest of the child. I want to again point out some special differences in New York, and actually that apply throughout the United States, that govern international child relocation cases. So, especially, the impact, certainly the impact of a future relocation on the relationship between the child and the potentially left behind parent is always a very critical factor. And there are cases that hold that any faraway relocation, especially an international relocation, will be expected to severely affect that relationship. Another critical element that applies right now to New York, and in our fact pattern, we're talking about Manhattan, New York, where the judges within the last few years have gone focused very much on the idea of joint and equal, 50-50. If they're living close by especially, unless there's a darn good reason otherwise, everything is equal, everything is 50-50, and the children go back and forth. I used to say when I oppose that kind of principle that children become like ping pong balls, but that's the starting point. So how can you have relocation in a world where the judges are focused on equality of time with the children? So these two factors I just mentioned mean that mostly a New York court will disfavor international child relocation, especially when the distances are significant. Our law in this regard is different than the law, for example, in California, where they call relocations move-aways, and it's significantly easier to get a move-away in California right now than it is in New York for various reasons. The wishes of the child in a New York case will be taken into account, but they are merely one factor among many. And there's one very special factor that I do want to refer to and describe, which is unique to the United States, which is again the effect of the Uniform Child Custody Jurisdiction and Enforcement Act, which is this uniform law that applies basically through all US states and territories. Once a New York court exercises child custody jurisdiction, under our law, the New York court will have continuing and exclusive jurisdiction concerning all matters about the child's well-being, even after the child is relocated to another US state or to another country, for so long as at least one parent continues to live in New York. That will fly in the face of the Australian law, which, as I understand it, is that the Australian courts will have jurisdiction to modify the initial New York order once Sophia is ordinarily resident in Australia. And this might very well influence the New York court against allowing any relocation, because there will be no way to guarantee that an Australian court will respect future custody modifications issued by a New York court, and there will be no way to prevent the Australian court in the future from modifying the New York custody order. In this particular case, the fact that mother is already an international child abductor, and if I was representing the other side, I would post a scarlet letter on her head as I'm describing this. She's done it before, Judge. She's going to do it again. She's going to go there and she's going to interfere, and et cetera, et cetera, et cetera. So how can we expose her to that? Your power, Your Honor, in New York is limited to New York, and she's already flown the coop if you allow relocation. There is a famous California case on this issue. It's called the Condon case. And the court in California in that case held that there was a duty on a court under the UCCJEA that allows a move away to a foreign country. There's a duty to impose measures sufficient to ensure that the terms of the California order, giving rights, for example, rights of access, rights of visitation, for example, giving rights to the left behind parent, that those California orders will be respected once the other parent relocates overseas. The problem with those kind of requirements is they have no power outside the United States. Whatever the American court says, its orders are not enforceable in Australia or in any other foreign country. In fact, what often happens is it becomes counterproductive because the removing parent, if there is an argument about the access terms in the future, the removing parent might obtain a modification order from a court in the new country, permitting her, for example, to limit vacation times in America. The left behind parent runs to the American court and gets an order that the removing parent or removed parent should be held in contempt of court and thrown in jail, except the mother is in Australia. What is the outcome of that? She'll never go to America again. And so it becomes extremely counterproductive. With respect to the facts in the present case, obviously, as before, I'm going to say that we need to know a lot more of the facts. And I think the evidence about whether a parent is more likely to uphold or to seek to thwart the contact measures to be contained in a custody order are going to be very relevant. The question that issue there will come down to whether the mother is legitimately painted as somebody who violated an agreement, who violated a deal, or whether she is more innocent. The final fact on New York in particular is that contested relocation cases in New York take a long time, take probably 2 years to complete, and a lot of discovery, a lot of lawyering, a lot of court conferences. Meanwhile, the status quo will be frozen in New York. This will mean that there will be a gigantic difference between the circumstances of the child on the day the case is filed versus the circumstances of the child on the case the day is decided. And the child will very likely have become more embedded in the New York environment at the end of that period of time. And that will be a very significant factor, and will work against the return, will work against the relocation request being granted. Those are my initial views. With respect to COVID, our courts are considering there are 1,000 cases on COVID. Basically, the courts are generally saying COVID will not reduce an obligation for both parents to be in the children's life. They're not open to too many arguments about COVID. On a temporary basis, if a child cannot get on the plane, they will consider that, and it will be temporary only. It will be very likely that there will be no permanent change based upon COVID. In a recent case, we had the court said both lawyers get on the phone, call the Spanish consulate together. Nobody's to call the Spanish consulate before the other lawyer is also getting the information from the Spanish authorities. Get on it together and ask them some basic questions. Here are my questions that I want you to ask. Get the information as to whether it is legit, legal for the kids to go back to Spain now, or what documents are needed, or if it's difficult now, when will that change? We did that and it worked out great, and the kids went back to Spain.
Thank you, Jeremy. Thanks. We do have a few questions coming in, and I think it would be good if you could answer some of those questions. But before we do that, Keturah, assuming there was a relocation filed in Australian courts, right? If you could just quickly summarize, right, how the courts would look at that. Thank you.
No problem. Yes, thank you, Teal. So Australia is quite similar, by the sound of it, to the US and to Malaysia. We do look at the best interests of the child, and that's under the Section CC of the Family Law Act. We don't have to show compelling reasons to relocate. That's based on a High Court decision of U&U. But I mean, coming back to this question of does a parent's past conduct in their unlawful retention or abduction mean that a relocation application will be more difficult? Likely yes, because the court does have to consider whether or not the parent who is seeking to relocate will facilitate an ongoing, meaningful relationship between the child or the children and the other parent. This did come up in a case back in 2009 in relation to a mother who abducted a child to Ireland. She came back to Australia and sought a relocation application. There was actually a history of violence in that situation. And interestingly, the judge said in that case, he said, look, whilst it would be inappropriate and improper for the mother to profit from her illegal action in removing the children from Australia, it is in the children's best interests, which must provide the focus for the court's attention. So we're really looking at best interests, all the evidence that goes to that, all the factors that the court takes into account, including the child's wishes, including, the arrangements that can be made for the child when they're going overseas as compared with staying in Australia, their family connections, their work, and all those sorts of factors. So it's interesting, and often we rely on family reports, experts' reports to really dig deep and work out really what's going on with the relationships. So violence does make a difference as well. So perhaps to go to your question, TL, in relation to how does the COVID-19 pandemic, how has that affected cases in Australia? Well, interestingly, on the Hague side of things, there's been a number of cases where they've tried to establish COVID-19 as a grave risk defence, and most of the time, as far as I know, it's failed. But interestingly, we had a recent full court case, which was a relocation case, and in the first instance, the judge, it was a case between Australia and Belgium, 5-year-old child. In that case, the first instance judge found it was in the best interest of the child to be permitted to relocate from Australia to Belgium with the mother, and there was a regime of contact that was permitted with the court orders. But on appeal, one of the grounds of the appeal of the father was that since the time the orders were made, COVID-19 had come into play, so he wasn't eligible to travel overseas to Belgium because he didn't fall under the exemption of the Department of Home Affairs to be able to travel aboard and see the child. So the court took that into account and allowed the appeal and said, look, this is going to impact on his ability to have an ongoing relationship with the child. Let's send it back to the trial judge and have a look at it again. So there we are. So a case that's recently happened. Thank you.
Thanks, Katara. I think if I just quickly share the Singapore court's perspective, in the interest of time, I can't do better than quote, right, the decision of our presiding judge, Justice Debbie Ong, in the case, right, of UYK and UYJ, which was decided in the middle of 2020, really literally in the midst of the pandemic, right, when it first reared its ugly head around the world. And Her Honour said this, evidence relating to COVID-19 pandemic could not be given inordinate weight. The COVID-19 situation is fast evolving, and depending on whether the situation improves or deteriorates, travel may or may not be allowed in the near future. The court should not be making orders on relocation depending on the COVID-19 situation at each specific point in time, as these orders will quickly become outdated as the global situation changes. So the approach of the courts is we're balancing all the circumstances, led to the conclusion that relocation is the best step for the child. In this case, relocation was granted to the mom to relocate from Singapore back to the UK. The COVID-19 situation itself should not hold the child back from relocating. So essentially, the courts looked at the longer-term interest of the child, and in this case, the child was a British citizen, the mom was a British citizen. So in the longer-term interest, they had benefits as a citizen in the UK, and that was also a factor the court took into account in deciding to make the order for relocation. Let me now just jump over the next 5 minutes to some of the questions that have been posed. One of the questions, perhaps I can address this to you, Jeremy, just to answer this. How do the courts in your jurisdiction deal with access by the abducting parent after the child has been returned to the country of habitual residence? If any, what are the usual conditions imposed by the courts?
So, the key is to ensure that the child is not punished by the misdeeds of the abducting parent, but that the child is safe and that the child will not be further removed. We have a problem in the US. We don't have any exit controls. You go to the airport, and if you've got a ticket and a passport, you can, you only have to satisfy the airline clerk about that, that you're going to be accepted into the place where you're flying to. However, if there is an order from a court that the child shall not be removed, then there is a special program operated by the US State Department with the Department of Homeland Security, whereby travel by public carrier, at least, cannot happen if the children's names and dates of birth are put onto a special list. So that's a starting point. We then have to concern ourselves with passports, making sure that passports are held in escrow. Initially, we may require supervised visitation only. Of course, that will depend dramatically on whether there was violence or not. And every case is different, but the courts want to make sure that the children are not hurt by being deprived of their access to one of the parents.
Thank you, Jeremy. Kutura, if I could pose the next question to you. What are your views on the issue of children born out of wedlock? Obviously, in a fact scenario, we're talking about marriage.
Right, well...
yeah, and would that make any difference, right, to the approach of the courts?
Good question, TL. Well, in Australia, we do have de facto partners have exactly the same rights now that married couples do. So, in essence, it wouldn't make any difference whether Marianne and Sergio were in a de facto relationship or whether they were married. It still comes down to mother and father, best interests, or, in the Hague case, the principles that apply about swift return and so on. So really no difference at all.
Thanks. And we probably just have time for about one more question. And Kieran, I think this I have to pose to you because the question comes from enforcement of a Singapore court order, right, in Malaysia, regarding access, for example, right? How would that be affected?
Access orders, so Singapore access orders to be enforced in Malaysia.
Yeah, so how to enforce a Singapore court order in Malaysia for a parent's access to a child who has dual Singapore and Malaysian citizenship and passport.
So, unlike financial orders where we do have reciprocal enforcement, the access order would either need to be mirrored. So if there's agreement, they could do that by agreement, and otherwise an application would need to be made. I'm assuming the child is in Malaysia, so there would be jurisdiction to make that application to have that order then recognized. So again, Malaysia would not be automatically bound by the Singapore access order, but it would be in the welfare of the child to see the other parent. So it would just be a question of, whether the Malaysian court can be persuaded then to say that that access order ought to be enforced in Malaysia because it is in the welfare of the child.
Thanks, Kieran. I think with that, we just have about enough time because the session ends at like now, according to my time. It leaves me to thank Keturah, Kiran, and Jeremy for the wonderful session you have joined us with in. Jeremy, thank you so much for staying late. I know it's way past your bedtime. You deserve your rest now. So thank you very much, all of you, for making this session a wonderful session of sharing of the different jurisdictions. And I look forward to seeing all of you all in person at some point in time in the near future, hopefully. And I'm sure that day will come for all of us. Thank you very much.
Thank you to all the panelists for all your sharing, and thank you, TL, for moderating that panel. Ladies and gentlemen, we've now come to the end of the morning's program and will break shortly for lunch. Before we do so, a few bits of housekeeping. Firstly, please note all delegates should view the 2 pre-recorded role-play videos prior to sessions 5 and 6, which take place tomorrow. You may access those videos from the MicePad platform under the Materials tab. Okay, remember, please do view those pre-recorded role-play videos.